from a man accused of child assault seeking to change bond conditions.
One more thing, Judge, that the allegations are that the daughter allegedly said that my client penetrated her every single day. There would certainly be medical evidence of that. Thank you.
To another facing drug-related charges with treatment concerns.
So is he in treatment now?
He is, Your Honor. And we're just
All right.
waiting.
You're just looking for time to see
Yes,
how
Your Honor.
he's, that's what you meant to say.
Yes, that's what I said.
Wow.
These cases show the realities of what offenders face. Starting with Mr. Worthington's case, here we have a man facing serious charges of sexual assault, suddenly requesting leniency in his bond. Let's watch how Judge Simpson deals with this case.
Okay, so the people versus James Worthington.
Good afternoon, Your Honor. Ellen Michaels on behalf of James Worthington. My P number is 67943. Mr. Worthington is present in court.
All right. Your name, sir?
James Worthington.
All right. Very good. All right.
So today's the date time set for our second probable cause conference. We'd adjourned it in order to get all the Child Advocacy Center videos. I'm short 2 videos, though I've been notified that they have been sent to me. So I believe we're ready to set it for exam, assuming that they in fact were uploaded today as stated by the prosecutor.
Clarification purposes, I have confirmation from the detective, the officer in charge, that they have just as of today been shared and made available on evidence.com. I've relayed that information to the proper individual in our office. I would expect that those will still be shared with counsel before the day is over. But just to be clear for the.
All right. And if those are done, then discovery is complete.
Yeah.
Yes.
I don't like to do it this way, but I get what you're saying, that it's there.
Understood, Your Honor. Thank you.
If there is a problem, I will bring it to the court's attention and file the appropriate stipulated motion in order.
Right. But that's what we try to give people time at PCC to get all that stuff straight and not set something and then have it adjourn out. So
Understood.
I want to make sure that we're going to be able to go forward. People had their witnesses available the 28th
28th of
January,
what time?
9 a.m.
Oh, I'm not available at all that day. I have a 9 a.m. exam and a 12:30 sentencing.
February 4th
Checking.
or February 11th.
What time? February 4th, 9 a.m.?
No, you're all at 9 a.m.
February 11th. February 11th is good.
Preliminary examination in person, February 11th, 2025, 9 a.m. before. Am I ahead on that list? Okay. Before Judge Valvo.
I didn't hear the name. What name?
Valvo,
Thank you.
bond will continue.
I'm asking Your Honor to again revisit the bond conditions. What I'm simply asking is that my client be reunited with his children. He does not need to go back to the residence that's across the street from where the complainant lives. The family can stay with a friend in a separate location, but since the incident that the 2 children of my client have been taken away, even though CPS has not filed any the case has been closed. There's no issues. The children are staying with grandparents, and this has been going on since early December.
Your Honor, people continue to object to that. Again, as I indicated the last time you were here with the same request, I get that. I really do. I'm not comfortable agreeing to that because although I understand that defendant's daughter was interviewed at the CAC and did not disclose. That being said, our charged victim, her first trial best friend, in her CAC interview, where she made all of her disclosures, she indicated that his daughter also told her that she had been sexually assaulted, both by defendant and by their son, who's 12. Well, I am concerned. I'm not willing or able to agree to change those bond conditions. Understanding, obviously, ultimately it's up to the court, but I have concern for the safety of any minor child.
And I'm quite frankly, counsel, I'm in the same position I was the last time, I think. That I don't think anything's changed, and I denied the request the last time, and I don't have any additional information that would lead me in that other direction. So I'm going to decline. I'm not going to change its bond conditions.
Can I just make a record on one matter?
Sure.
Thank you so much. My client's daughter, Lila, who the prosecutor was talking about, she was taken by the police to University of Michigan Hospital and physically examined. There's no indication of any sexual assault. She was also, as stated, interviewed in a forensic setting and did not make any disclosures. We believe this is all part of these are all false allegations, and the children, there's no evidence that his children have been assaulted in any way. This is part of the discovery that was tendered to me by the prosecutor, the medical records and her interview.
Judge, as I indicated last time, same record was made then, same arguments were made then.
I know.
Certainly the court has been doing this as long as I have been doing this. There aren't hardly ever medical findings when a small child has been sexually assaulted. It's all about timing. It's all about type of sexual assault. It's all about those areas of our bodies being fast healing. It's all about so many moving parts that a lack of medical information means zero things in terms of whether or not a child has been sexually assaulted.
One more thing, Judge, that the allegations are that the daughter allegedly said that my client penetrated her every single day. There would certainly be medical evidence of that. Thank you.
It would not necessarily be. Penetration can be a whole lot of things with a whole lot.
Yes. And again, I know you made your record, but I'm still at this point going to deny that. Judge Valvo, after the damn happens, may feel differently, and certainly you can bring that before her. But at this time, I'm going to deny the request. God will continue.
Thank you very much.
Unlike Mr. Washington, this time we have Mr. Jordan, who has violated the terms of his probation by failing to meet drug testing requirements.
How's the case of People versus Christopher Jordan?
As one of the people.
Good afternoon, Judge. EA Board 261 here on behalf of
All right.
who is not present.
Who's not present?
I was wondering maybe we could do this without him.
Not for long, we can't.
Your Honor, I know the court has received the
Violation.
bond violation report from community corrections indicating that no tests from therapeutics have been sent over, and defense counsel was kind enough to provide correspondence from therapeutics dated yesterday, indicating that the defendant had been doing meetings and some other things with therapeutics. But as I looked through that paperwork, I wasn't able to see a record of any drug testing.
Testing.
So I'm not sure if I missed something. It's certainly possible, but I didn't see anything in that correspondence that had that in there.
It's, sorry to interrupt. It's on the top of the second page. Client is in phase 1. He provides urinary drug sample.
It doesn't include testing.
Yeah, that's right. I figured there would be some testing component to it, but I don't know where are the results of those tests?
I don't have the results of the test. Therapeutics, I understand, is doing the testing and continuing to provide Mr. Jordan with the methadone that is part of his treatment.
Okay, but are they sending the test to our community corrections?
Unfortunately, it seems that they are not. So I don't have the results, but I do have record that Mr. Jordan is in treatment. He is living homeless, as I was explaining to opposing counsel. He's availed himself of a lot of resources here. There are 2 volunteer social workers from the warming center that asked me to step into the case. I'm on this case pro bono. So Mr. Jordan is in treatment, and I apologize to the court that I don't have the records of the drug, the sort of results of the drug testing, but he's availing himself of treatment. He's in, he's attending these meetings, both individual counseling sessions and group meetings. And the other thing that I think is relevant to the court is Mr. Jordan, this is a case from 2022, 2.5 years ago. And there's a more recent case. He was charged with a misdemeanor, and we resolved that last year with the prosecutor's office dismissing the case pursuant to Mr. Jordan being in treatment, which he's still in treatment. And so it feels a little counterintuitive that we dismissed a more recent case for Mr. Jordan's compliance with treatment, which he's remaining in compliance with. And we've now charged him with a felony from 2.5 years ago. I'd asked the court.
So you should say the prosecutor should not do that kind of thing where, I mean, if they've got to be intuitive, that means everybody should get charged and just go for it. Never mind. Go ahead.
I'm asking that the court, because this case also involves an extremely questionable stop by the police and search of Mr. Jordan as he's walking down the street or jogging down the street. I'm asking that the court, before a warrant is issued on such an old case where there is a questionable, there is, I argue, a Fourth Amendment violation.
Okay, I get that. If he got here, then we could have the hearing on all of that.
Yes,
But he's not here.
understand. He's ill. He's living homeless. It's been extremely cold outside. He's managed to continue to get himself into treatment. So I'm just asking that the court hold off on a warrant and allow us to litigate the legitimacy of this arrest without a warrant issuing.
Well, I'm going to issue a bench warrant for his failure to appear at this proceeding. And I mean, I might not do that if I had test results coming in, given the circumstances, but I really, none of this really puts a picture together for me of where the defendant is or what he's doing, and certainly not testing. So I'm going to issue a bench warrant. Bond will be set in the amount of $25,000 cash surety. If you locate him and can get him in, there's a warrant recall procedure you can go through on this. That warrant will issue immediately.
Here is Judge Simpson dealing with another probation violation, this time by Mr. Torer, who has failed to comply with his bond conditions.
Court calls case People versus Cody Tournier.
Is that on behalf of the people?
Good afternoon, Your Honor. Charlotte Steffen on behalf of Mr. Tournier. Excuse me, Tournier.
Cody Tournier. All right, what are we doing?
Your Honor, we are ready to set this for exam.
Okay, I don't necessarily have a problem. You see the new violation report.
Yes, Your Honor.
All right, what do you want to do about that?
Your Honor, he's acknowledging that he's in violation of his bond conditions. He does not have money for testing. He also doesn't have transportation for testing. Additionally, Your Honor, he has a medical condition that causes him to have great anxiety under those testing circumstances, and historically has not been able to provide specimens, even if he had transportation and money.
So basically,
Well, except that on December 18th, he was able to do so.
by force, basically, I had to force myself to do that along with the rest of the tests. But last time that I went to go drop and do my test, my kidneys hurt so bad, I almost felt like I was going to pass out, basically. My body just wouldn't let me.
Here's my problem. When I'm looking at this looks like somebody that just doesn't want to cooperate in the process. He tests, then telephones in right before Christmas saying that he didn't have the money to test. Then the next two tests that are scheduled, he just misses. Then the next test, it's an unable or refuse.
I'm not trying to play. I'm sorry if it looks that way.
Your Honor, could the prosecutor and I approach?
You may. Record to reflect the defense conference in this case. What I'm going to do in this case is I'm going to adjourn your probable cause conference out, check into alternatives to how to resolve this case. Would February 6th or 13th be better for you?
February 13th is a good day, Your Honor.
All right. February 13th, 2025. I'll set it at 9, but you'll get an invite with the time. And then with reference to his testing, at this point, not going to violate the defendant on the report. What I'm going to do is I'm going to switch his testing, and so you'll have to appear and they're going to do a swab. Okay. I usually don't do that, but I'm going to do that in this case because I really want you to test. Got it? Okay. And so we'll sign that order. Is that?
Transportation.
Right, spot on it, because I think we have to help you.
My girlfriend said she'd take me.
Oh, we're off my bed.
Yeah. All right. So, and I don't know, you can check how many times he had it. So that order would be over there, and you may want to go over at this point. Do you know when your next test is supposed to be, or they
I
haven't called you?
haven't been able to figure out from what I knew it was supposed to be this week, and I tried to test and it wasn't able.
All right. So here's what I'm going to want you to do. Since you're here on this campus right now, I want you to go over and see if they can get a swab in today. That way to start it out, and we'll send over the order. Okay?
Thank you, Judge. And one last thing.
Yes.
He missed a court date this morning with Judge Freshour, and she
He did.
said that perhaps we could address that with you while we were here.
He missed it this morning with her.
Yes, it's a separate matter. It's a
Do you
mystery.
have a case number on it? Let's see.
Yes, I do. Your Honor.
Let's take a look and see what they did.
It's 24F41587FY. Oh, I'm sorry.
No, that's us.
I'm sorry. It's 2440331 SM.
I have no information about it's not updated. I can tell you it's a DD misdemeanor. It was scheduled at 9:30.
It's scheduled at 9:30 this morning. Okay. We get to Lindsay, see if we could do something to reset him. Your counsel of record on that?
I am, Your Honor.
Okay, so, okay, if you give us a minute, she's gonna communicate with them. They're actually in the building.
Wonderful.
And let's see if we can either get it, if they issued a warrant to cancel the warrant, get him reset, give you a day, or if at worst, give you the bond recall information and let you go through that process. But
Thank
let's
you
see
so
if we
much.
shortcut that, okay? All right.
While Mr. Torer faced charges for probation violations, let's now watch as Judge Simpson handles a plea sentencing in another case.
All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied, Your Honor.
Satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count three. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 15th District Court Probation. Sentencing in this case will be February 14, 2025, 8:30 before Judge Perry.
Judge, I have to inquire, is that the earliest possible date? I know that my client, he's currently going to U of M, and he has an opportunity regarding one of his classes, and I know that potentially he might have had to leave the state of Michigan. I was curious if there's any earlier date that I could get.
You'd have to call down to Judge Perry's office and see if there's an earlier date. That's the date they give us to give for sentencing in this case.
Will do, Judge. I'm sorry, and that was February 14th at what time?
8:30.
Thank you, Judge.
And finally, this last case focuses on Mr. Wilson requesting a 30-day adjournment to provide proof of treatment for his drug addiction.
Court calls case People versus Madison Welson.
And on behalf of Mr. Welson, who's appearing to my right, please state your name for the record.
Madison Wilson.
Andrew Childers appearing on behalf of you.
At this time, we would like to ask for a 30-day adjournment, Your Honor.
Why?
Seeking mitigation information,
That's not what this says.
proof of treatment.
So is he in treatment now?
He is, Your Honor, and we're just
All right,
waiting.
you're just looking for time to see
Yes,
how
Your Honor.
he's, that's what you meant to say.
Yes, that's what I said.
Wow. Didn't listen to
I
how.
gotta read these quick lines.
No, she says exactly what's on her mind. Gonna get her in trouble, but she says what's on her mind. All right. So how far along are you in treatment? How long have you been in?
I want to say the week after I got out of jail, I enrolled in the IHA medical.
Okay.
Program. I'm in that. I'm attending AA meetings, paying my supervision fees. So I'm pretty sure I've been in there this whole time.
Okay.
My scripts every month.
Got it.
I see my doctor once a month,
Once a month. Okay. So why don't we do this? Let's,
and I do drug tests with her also.
pardon?
I drug test with her also.
Her also.
Top of community correction.
All right. Probable cause conference, February 20th, 2025, 9 a.m.
Thank you, Your Honor.
All right. Good luck to you, sir.